Studer v. Hines, file 24-9075NO. Being back on our civil docket, we are providing public access not only in the courtroom but also online. And counsel, you want to state your appearances, beginning with plaintiff.
Judge Mike Flagstead, P number 79314 on behalf of Mr. Studer.
Good morning, Your Honor. I'm Jack Deegan. I'm on behalf of the defendant. My P number is.
I don't requare that sort of thing. Yeah.
He said it, so I want him to.
That's fine. You wanted to say you had an earlier one or a later one?
Yeah, no. Strike that. Yeah. You got me by 20,000.
All right. Thank you very much. All right. This is defense motion for summary disposition. And before we get into the merits of that, there was a brief, a response, a reply, and then a supplemental brief filed by the plaintiff. And Mr. Deegan, you have objected to that supplemental brief. You want to say anything about that objection?
I do briefly. And I don't normally file objections like that, but this is an important motion to me. And I do believe that their supplemental filing doesn't follow the court rules. Generally under 2119, I file a motion, they file a response, and then I get 5 pages to reply. Within their response to my motion for summary was arguments as to the work comp lien and also what it looked like a motion in limine, and then a couple paragraphs as to I-2. A lot going on there, 2.116 I-2. But I kept my response within 5 pages. So I was very surprised then when I got another supplemental response. And I did object. I can find no basis for that under the court rules. And so I filed that objection to preserve the record. That is the purpose of my objection, Your Honor.
Okay, thank you. Mr. Flagstad, what's your response to that?
Judge, I hope the court received my response, my written response to Mr. Deegan's objection. If it didn't, I'd be happy to.
I did.
Okay. Judge, I do believe 2.116 G1A is the correct part of the court rules. And what G1A indicates is that when a party files a motion, gets a brief, the non-moving or responding party gets a response, and the filing party gets a reply. And Judge, I would indicate that's exactly what we did.
Yeah, except you didn't. You didn't file a motion. You filed a response to a motion, and in that response, you asked for partial summary disposition in your favor under what I-2, where if it appears to the court that the opposing party rather than the moving party is entitled to judgment, the court may render a judgment in favor of the opposing party. So it's perfectly appropriate for you to ask for that remedy, which you did. That doesn't make it a separately filed and noticed motion, does it?
I would agree, Judge.
So you didn't file a motion.
We did style our motion in brief a counter motion in brief.
Right. By skipping the notice of hearing,
we filed notice of
skipping the notice of hearing timing requirements, skipping the filing fee. I mean, you're filing a response and saying my response is not only a response, but like 2 other motions, but I'm not going to file them as separate motions. That doesn't seem consistent with the court rules at all.
Well, I'm sorry, Judge. I'm jumping at the bit and I'm interrupting you.
No, go ahead. And so I'm just wondering, then it looks like you're asking for here's an old-fashioned word for you, a surreply. There's a motion, a response, a reply, and then sometimes if the court allows it, a surreply. But that seems to be what you were doing. Explain to me why I'm wrong about that.
Judge, we did file a notice of hearing with this time and date. It did comply with the notice requirements. I believe it was 24 days prior to today's date. We did submit a check, Your Honor, for a separately filed motion. There was a filing fee. We consulted with the clerk whether they would like an additional filing fee for the counter motion. I believe the answer was no. And furthermore, Judge, as we indicated on the face of that counter motion, if this action does not please the court, we would be more than happy to back off from that, separate out our motions, or have it heard another day, Judge. Certainly it's at Your Honor's convenience. If it is not convenient for Your Honor, we would be happy to separate that out. Our thought process, Judge, was kind of twofold. The 2116 subpart, which I can't cite off the top of my head, does seem to encourage consolidation of motions. And moreover, Your Honor, we'd be looking at essentially 3 motions and briefs across 2 separate days on the exact same facts and issues. That was plaintiff's thought process. If it does not please the court, if it is not convenient to hear our motions, we would be more than happy to separate those out to a different day, Judge.
Your response, Mr. Deegan?
Briefly, this is a simple process. This is the first time I've dealt with this kind of strategy and trying to get around the page allotments. And what I do believe is an attempt to make this confusing and try to indicate there's some issue of fact, which I'm going to argue there is not in my motion for summary disposition. What I heard was, okay, you got all this stuff in front of you now, but now I'll have a separate motion for partial summary disposition, a separate motion in limine. And that's not appropriate. What we're here for today is to argue my motion for summary disposition. They did say 2 paragraphs, and I'm going to argue without basis that somehow they get dispositive motion under I-2. The fact of the matter is we have a bunch of paperwork. I hate finding objections, but I had to protect the record. There is no court rule that allows this type of procedural play. I think my objections stand or should be granted.
All right, thank you. Well, as a matter of the court rules, the defendant, I think, is absolutely correct. The plaintiff, in the response to defendant's summary disposition motion, could argue that they're instead entitled to summary disposition under I-2, but this doesn't trigger the option to file a cert reply. To the extent that plaintiff's motion was styled as a separate motion of some sort, it wasn't filed as such. That practice did not comply with the court rules. Defendant's reply was the final brief on the only pending motion, the motion for summary disposition under 2.116 G1A, and no supplemental briefs may be filed without leave of the court under G1A4. Having said all that, I mean, I read it, and courts can disregard stuff that I strike, of course. But also, I guess I'll say, I don't recall if we've had a case, Mr. Klagstead. I'm not remembering it. So this, I'm taking as Mr. Klagstead's first appearance in a civil matter with me. And there are some areas where the court rule doesn't, cleanly address some issues. What I would prefer, Mr. Klagstead, you do when you've got questions like that is see if you can get opposing counsel on the horn. And I'm very amenable to phone conferences with folks to sort out issues like that. What does not please me is then when stuff is just filed and then there's a footnote dropped for me to let you know if you should do something different. I mean, how courts work is when you file stuff, I try very hard to be a judge who's prepared for court, which means I'm reading them in advance of court. But usually that's not a matter of several weeks before the motion hearing.
Understood.
So I'm reading this footnote at the same time I'm reading Mr. Deegan's objection to what you've done. So that sort of approach doesn't really give us time to sort that out. So because I'm going to give some grace and not strike the brief, but let Mr. Klagstead know. I think Mr. Deegan's absolutely right about those court rules. And in the future, follow those. Or if you want to do something different, pick up the phone and we'll talk.
Okay. I'm satisfied. Thank you.
Okay, very good. All right. So, and you can have a seat. You don't have to stand the whole time. And I let you argue from the podium or from the table, seated, standing, whatever you want to do. Mr. Deegan, go ahead.
Yes, Your Honor. And this is my motion for summary disposition. First of all, I do have a C8 aspect of the motion, and I won't go into great detail.
That's as to the count 2 negligence.
Yes, sir.
Which it seems to me would only survive if Mr. Klagstead was pointing out, hey, gee, you've raised a question about where this might have happened. And if it happened on the public area because of some improvement your guy put there,
possibly,
then that would be a valid negligence count. But it doesn't seem like anybody's claiming that's actually what happened.
No, and I cited some of the case law that would discuss that. For instance, if I had a piece of property near an alley and then something was flowing into that I caused, and then I do agree, but there has been no allegation of that sort. So I do request that count to be dismissed.
Or if your client had placed landscaping stones in the public beach area, the plaintiff accessed the public beach area and somehow was injured by the placement of those landscaping rocks, that could be a negligence claim.
There has been that's possibly that your hypothetical may. makes sense. However, there is no evidence that any of the landscaping rocks were put on a public right of way.
All right. It sounds like the plaintiff is maintaining that although some folks may have had unclear understanding or recollection about ownership or lines, that the plaintiff's claim depends upon the fact that this happened within the easement.
It would, because with no evidence demonstrating that we breached any duty or even affected the public land, there is no argument as to a potential negligence claim.
Okay, and I know you pointed out some of those discrepancies about the location, just if it helps both parties to understand. I looked at all that and thought, there doesn't seem to me that those discrepancies rise to the issue of a genuine issue of material fact about the location. And I'm analyzing this as if the injury occurred on the servient estate of the easement, within the easement.
That is my understanding, Your Honor. And when you speak to issue of fact, that goes to C10 and has to count 1. And in this case, and you look at the case law, the burden is on them to show that he was not a trespasser. That is my allegation. This is an easement that has been placed a long time. The grantor of the easement is a lady named Diane Haight. Her daughter is Dawn Boulder. The easement is simply for ingress and egress to the beach. That is it. Diane Hayes testified she never gave permission or authorized or asked Mr. Studer to come on premise. Her daughter also said, I never gave permission. My client certainly did. And then I have communication from counsel for the county that says he was not authorized to do this as a planner. With that being the case, this is a clear case of a trespass and an injury that occurred. My client never had any notice, certainly didn't have any idea. And understand that the rocks at issue here had been placed about a year prior. And they were for purposes of erosion. They weren't to prohibit anybody. You could still have access. So all the testimony is very clear that Mr. Studer, for some reason, found it appropriate to come onto this easement, which he is not a party of. And he found himself hurt. And now he sues my client. And that's inappropriate. Let's take it a bit further. If it's a trespasser, they have to show that we willfully or wantonly injured him. And
there's no indication of that.
There is none. If he's a licensee, we have to show that we knew of something that was dangerous, and we didn't take any care. But the duty there is quite limited too, as the court knows. And so with that being said, even if he is a licensee somehow, which I can't see, there's no issue of fact as to whether he's possibly a trespasser, let alone licensee. And I think it's been admitted that he's certainly not an invitee. Going forward, so there's no issue of fact. And the cases I've cited show that it is there in Tripp versus Baker, All-Star versus Glidden. Tripp versus Baker, the court says, where plaintiff failed to produce evidence creating an issue of fact on the point of a trespass, their case fails. There's another problem too. Is this,
Mr. Deegan? I got a couple of questions for you.
Yes, sir.
What about I want to go back just a moment to the licensee issue and your argument, and it's in the briefs, that if the plaintiff is a licensee, your clients should still win because they had no notice of this defect, this hole.
and that's
And that would normally, and you and I have had some cases that turn on that precise question.
we sure have.
And, I know there's some merit to that as a general proposition, but in this case, it sounds like the facts are that the depression would be as a result of work that your clients did, putting that in, by putting in the soil and the sod, and then it settles and there's the hole. So do those general notice rules apply when the defect on the land is a result of actions that the landowner took?
I hear you, Your Honor, and that is complete speculation in this case, because the next point I was going to get to, let me go back to licensee. First of all, a landowner owes a licensee only a duty to warn of hidden dangers known or with reason to be known by the owner if the licensee does not know or have reason to know.
Sure. So that gets to the, would they have reason to know if it was
Correct.
caused by their actions?
And now that's why I had indicated to the court that these landscape rocks had been in place for a while. No one had ever said they had a problem. We had no reason. Nobody said, hey, it's weird out there. And understand too, he stepped on the rocks and stepped off. But we've never had any indication. My client has used this. Diane Hayes, who is the grantor, and her daughter, they have never indicated that there was a problem. And the other issue too is you go to not only notice, but they don't even seem to know what exactly caused. He stepped off. Maybe it was soft. Maybe there was a hole. There seems to be speculation as to even what caused. Could it have been just simply stepping wrong? Happened to my neighbor last week, broke her foot. I don't know.
Well, and as to the notice, this is more a question for Mr. Flagstad, but it seems to me like, how would you have notice of that? Like, you wouldn't expect people are just going to be walking on top of the landscaping rocks. They're there for decorative purposes, not for a walkway.
They are, Your Honor. And so I think in this case is a bit unusual than the other ones I've had in front of you in other courts. It's pretty rare that you get a situation with a trespass that we argue. And normally you have an invitee situation.
Sure. Now, if he'd been there with Miss Hayes, he wouldn't be a trespasser, right?
Well, that's still debatable because I think that having this individual come on for an investigative purpose, though not authorized by the county, I would have trouble agreeing with an argument that he was an invitee.
That's an interesting question to me. And I wonder, I'm thinking back to my days as a private practitioner, which might have been a few years ago. I remember going to various clients' premises when there were disputes about their property. As an attorney, I remember walking with clients on easement areas. And I guess I didn't believe that I was trespassing when I did so for my client to show me this is what's going on here so that I could finish my investigation for purposes of filing a claim. So if Ms. Hayes was there with her lawyer, would that be a trespass?
I think if she was there with the lawyer, they would need to give notice. Hey, I'm coming on the easement with the lawyer, or I'm coming out with a public official. If you as an attorney judge had gone out to property to investigate with the client, I think you would have to give notice. And that's something I argued. We didn't even get notice that they were doing this investigation. I think it's kind of outside of the realm of what we're dealing with today. But however, and first of all, Miss Hayes, who has the easement, didn't even call him. So your hypothetical is interesting to me. It's an intellectual debate, but that didn't happen. She didn't even contact him, nor did the daughter. And so we're still trying to figure out why he was even out there. And so I have trouble with any type of investigation going on. But I think that would, at best, maybe because you wouldn't have the invite, it would maybe be a licensee issue as opposed to, but definitely not an invitee. But the burden is on the plaintiff in these cases to show he wasn't trespassing. And they've got nothing. We've taken a lot of depositions in this case. And no one has ever said he had permission, he could do this. And he also exceeded the scope of the easement, which was simply for ingress and egress, not for investigation purposes. And that's why I took care and speak to counsel for the county to say, hey, has this been authorized? And the response said, no, he was not. He was not in the scope of employment. And it was pointed out specifically in the letter that actually there would be no reason to be there. The site plan, the zoning, everything had been taken care of. There are no issues pending on this property. So an investigation.
There's no zoning issues present on the property. And are you aware of any provision of the zoning ordinance that would be implicated by a servient estate owner's interference with the dominant estate owner's easement rights in a private easement?
I am not, Your Honor,
Neither am I.
but I am not aware of any allegation that we have. There's been no formal filing. There's been no lawsuit or.
Right, but even if there were, that's a matter of a private property suit.
It's a private property situation. And in this situation, for some reason, he wanted to come out, look at it. I don't know why, but at his own peril. And so I think that there are no facts that support keeping this claim alive.
All right, thank you.
You're welcome.
All right, Mr. Flagstaff, your response.
Might I remain seated here?
Yes, that's fine.
Thank you, Judge. The first point, Judge, I bring it up because I'm surprised to hear defense counsel say it today, that there's no argument that the accident occurred in the public beach area. To the contrary, Judge, on page 7 of my response brief, I cited exactly where defendant has said that. And I only cited it the one time in their initial disclosures because I didn't expect it to be a contested issue. I believe they actually raised it as a defense. Furthermore, Judge, and Mr.
Right now, but I mean, I looked at all of that, and there's lots of interesting stuff at the edges, but really, you're saying this happened in the easement area.
My belief when we filed the suit was that the hole was in the easement area.
Yeah, and I think it was. I mean, there doesn't seem to be a genuine issue of material facts about that, and that's the. I mean, would you agree with that?
I would agree with you that that's the central thrust of an ordinary negligence claim. Yes, I think you've correctly identified.
So that would mean that count 2 should probably be dismissed on a C8.
Other than the fact that when he's deposed, Mr. Hines insists it certainly was on public beach, and Mr. Harris points out to him at the time of the deposition, "Are you sure this is the route you want to take? I mean, you think this helps you?" Oh, for sure, it was on the public beach area. And Judge, if they want to create that issue of fact, I think. Let them lie in the bed, take it to a jury and let a jury decide that that's not true. Candidly, Judge, I would rather a jury see that exchange and test that truthfulness for themselves.
Okay. Well, I mean, I'm not interested in leaving counts alive just for the jury to play around.
Understood.
So I mean, I'm almost certainly granting C8 on count 2. I'm much more interested in count 1. Why is Mr. Studer not a trespasser on the Hines' property?
A number of factors, Judge. First of all, again, responding to Mr. Deegan, he said there's no testimony that anyone invited him. That's just not true. Dawn and Diane, Ms. Petrius and Ms. Hayes, both indicate they wanted him there. Dawn indicates, yes, I asked him to be there. Ms. Petrius further says, now I admit, Judge, this is a factual difference between the two depositions. Ms. Petrius says, yes, my mom knew I was asking him to be there. Ms. Hayes said, it's good that he was there. I would want him to be there. He was doing the right thing. Now, admittedly, Judge, she indicates that she did not call him. However, Judge, the testimony is that she set up a survey that morning, asked her daughter to march down there because she was in Florida and document the survey because she had a feeling those stakes would not remain.
Do you think that easement would allow Ms. Hayes to bring guests?
I do, Judge. And Judge, it's an interesting point that you raise for a couple of reasons. Defendant spent 2 pages of law trying to convince the court to narrowly construe the easement, and at least 3 different arguments that hinge on how they say the court should interpret the easement. But they've only pulled 2 sentences from the easement itself. If you actually read the easement, it's quite raw, and the language is not good for defendants. The easement indicates it shall run with the land. It shall bind and benefit the owners and occupiers of the benefited parcels, which Dawn is. There's no serious dispute here that she is an owner.
Well, I'm not sure that's true.